Hello everybody and welcome to another study video for constitutional and administrative law on the Law Academy. This is a further free study video. If you want to get access to all of these as and when I make these lessons, essentially just going through and providing a little bit of study revision for each of these topics, then go and get yourself a membership on the Law Academy. This not only gives you access to a lot of other videos as well, a lot of content that is available only to members, but it also helps this business and this channel carry on in the way that it is. But for now, what we're going to do in this video is talk about the structure of government, and you can sort of see a general outline of what we're going to be covering here. And essentially what I'm going to do is begin this topic on the structure of government by looking more generally at the idea of the separation of powers. Now, the separation of powers implies a number of things, and within the broader corpus of constitutional theory, one liberal idea derives out of the Enlightenment this concept that powers specifically ought to be separated. And this is to be separated into various different institutions. Now, one of the reasons why this is so important and why this is so prevalent is so that no one person or no single institution can become too powerful and establish themselves as a dictatorship, a formal dictatorship or a totalitarian state. And so when we think about the separation, the separation of powers in this regard, we tend to think about separation of powers divided into three major constitutional institutions. The first of these is the legislature. The legislature is responsible for the passing of law. The second is the executive. They are responsible for executing the law. They are responsible for enforcing the law. And then the final of these is the judiciary, which is responsible for the interpretation of and the application of law on disputes. That's the traditional framework for how we think about the separation of powers. Now, in the United Kingdom, we have a slightly different process on the separation of powers. So, while we do have some kind of jurisdictional and formal separation of powers that is enshrined in our constitutional framework, we have a very limited separation of powers when we compare ourselves to other institutions. So if we, for example, were to compare ourselves to the United States, in the United States there is a codified constitution, and that codified constitution means that they clearly and very formalistically separate powers into three distinct branches of government. This is at the federal level because they also separate powers vertically between state and federal and local governments. And they also separate powers internally. If you think about, for example, the bicameral nature of Congress and the clear division of powers between the House of Representatives and the Senate, there is a division of powers there as well. But ultimately, their separation of powers is very clearly set out in Articles 1, 2, and 3 of the US Constitution, and it is very clearly separate in the sense that a member of Congress is not a member of the executive. A member of the executive is not a member of the judiciary. Before the implementation of the 2005 Constitutional Reform Act, this was in 2009, was when it was implemented, all three branches of government, the executive, the legislative, and the judicial branches, all three of these branches sat inside Parliament. The highest judicial office, for example, was in the House of Lords. They were the Lords of Appeal in Ordinary. This was changed with the formal establishment of the Supreme Court. This separated the institutions. This created a sense of clear blue water between the Parliament and the legislature and the executive on the one hand, and the judiciary on the other. Today, however, we still do not have a formal separation of powers in the sense that we have when we think about the United States. So, for example, while we do have a separation of institutions between the judiciary on the one hand, there is still nevertheless a fusion of powers between the executive and the legislative branches on the other. So this basically means that the executive branch sits in the House of Commons and are derived out of the legislature. Government ministers are made up of members of Parliament, have constituents that they represent, and they vote on passing laws through Parliament. In continuing thinking about then the structure of government, let's think about one of the most important principles or one of the most important institutions within this framework. This is Parliament, okay? And Parliament is what we call a bicameral legislature. It is bicameral because it is a legislative institution that is divided into two distinct chambers. So this means that there is one body and there is another body. You sometimes have unicameral legislatures where it is just a single institution. You sometimes have tricameral legislatures where there are three institutions that sit within the legislature. Bicameral legislatures are those that have two chambers. In the UK, these are the House of Commons on the one hand. Now, the House of Commons is the one that is the elected chamber, and even though it is described colloquially as the lower chamber of Parliament, it is the one with the majority of the power, because it's the elected one. And so, as time has gone on over the years and over the centuries, we see that more and more power has been unified in both Parliament and then specifically in the House of Commons, owing to its democratic nature. You then have the upper house. This is the House of Lords. Now, the House of Lords, of course, is the institution that is unelected. It does not have elections. It has people, the executive appoints peers to the House of Lords. These and they have a significantly less authority than that of the previously aforementioned House of Commons. A major principle within our constitutional framework and within the structure of our government is this idea of the parliamentary sovereignty, the sovereignty of Parliament. Now, the doctrine of parliamentary sovereignty means essentially what it says on the tin, that we have the fact that when it comes to lawmaking, when it comes to the making of law, Parliament is sovereign in that endeavour, okay? This means that they are the supreme lawmaking authority, and no one, not even the courts, can challenge or invalidate an act of Parliament. They can only interpret an act of Parliament. Now, there are different implications and associations with this principle, and we're going to do a whole video on the parliamentary sovereignty doctrine in the future, a full mind map in the same way. And this is a principle that has been modified, for example, by the UK's membership to the European Union prior to Brexit, the incorporation of the European Convention on Human Rights, the ECHR, into domestic law via the Human Rights Act, and additionally devolution is granted a number of powers to the Scottish Parliament, the Welsh Synod, and the Northern Ireland Assembly. These devolved institutions, while theoretically having legislative powers, derive their legislative powers under and as the result of parliamentary legislation. So they are still subjected to Parliament's authority, their legislative authority. It's very important to remember as well that the UK's government system operates as a constitutional monarchy. And this means that the monarch's powers are largely ceremonial and symbolic, but that the monarchy still does nevertheless exist. The monarch's role is governed by constitutional law and by conventions, which therefore limits their powers and requires them to act on the advice of their elected officials, primarily the Prime Minister and government ministers. And the monarch's role includes a number of different, relatively ceremonial processes. So it includes, for example, the opening and the dissolving of Parliament, the granting of royal assent to legislation, the representation of the United Kingdom at home and abroad. And so ultimately, because the UK is a constitutional monarchy, it still plays, the Crown that is, still plays a significant role in the administration of government. The executive powers which are conferred onto the Crown in their authority as monarch are known as the royal prerogative powers. By constitutional convention, the power of the prerogative is conferred onto members of the executive, and that is because, firstly, we live in a democracy, a constitutional monarchy, in the sense that, therefore, if we're thinking about powers of royal prerogative, that has to be conferred onto the democratically elected members of the executive. But secondly, and very importantly, they are conferred onto the members of the executive, who are then held accountable to Parliament, the supreme legislative authority in the United Kingdom. The monarch, when they do act, they will act on the advice of the Prime Minister, and can only act on advice of the Prime Minister or other ministers within the executive. They cannot seek or get advice or act on advice that comes beyond that of the government. That would be unconstitutional. And so, as you can probably imagine, the executive branch is very, very interesting. Now, the executive branch of the UK government is often confusingly also called the government. So when we talk about, for example, the House of Commons, and we talk about parliamentary politics, there is a distinction that we make between Parliament and the government. The government are those who sit on a particular side of the House of Commons. They are those who command a majority in the House of Commons, who then therefore formed a government in the name of the monarch. And those are the ones who form the executive branch. They are part of the institution that is tasked with the role of executing the laws and implementing policy. Now, the government has the responsibility for drafting and implementing laws and policy within the United Kingdom. The executive is formally usually when a political party wins the majority of seats in Parliament. But it should be cautioned that this is not always the case. Okay, you can have coalitions, you can have situations where we have historically not seen this taking place. Ultimately, this is a convention. The convention is that the monarch will call the leader of the largest party when they have won the election, and they will then be called to form a government. They will be invited to form a government in the name of the monarch in question. Now, the structural part of the UK executive branch is known as the civil service. This is the sort of bureaucratic centre of the UK executive branch. It is the structural part of the executive, and it is the vast network of individuals who run and work the day-to-day implementation of government policy. So some of the basic tasks which are provided by and performed by the civil service include things like the paying of benefits and pensions, the issuance of student loans. For those of you who are at university, this is particularly important to you. The running of pensions, the issuing of driving licenses, all of these kinds of things, the sort of day-to-day runnings of the things that you would be concerned in as a member of a government. Finally then, just before we conclude, I want to focus on this concept known as devolution. Okay, what does it mean to talk about devolution? Well, devolution refers to the transfer of certain legislative powers from the UK Parliament, from the Parliament in Westminster, to regional governments in Scotland, Wales, Northern Ireland, and the City of London. People often forget about the City of London because it is not cited as much, but at least specifically Scotland, Wales, and Northern Ireland. Each of these devolved legislatures has its own areas of competence. What I mean by this is areas of policy that they exclusively run and operate. So health, education, transport, and things of that kind of nature are things that are the exclusive competence of the Welsh Assembly, the Northern Ireland Assembly, the Scottish Parliament, for example. Other areas of policy, like national defence, foreign affairs, nuclear policy, and some environmental policies, these are all what we call reserved powers. And these are the powers that are reserved to the UK Parliament, to Westminster. It wouldn't really make sense, for example, if we're a united kingdom, to have multiple different foreign policy objectives coming from each of the different parts of that government. In a similar way that a federal state like the United States, the idea of foreign policy is exclusively the remit of the federal government. You won't see the state of Texas operating foreign policy differently to that of the state of Ohio, for example. Now, the idea of devolution is authorized by pieces of primary parliamentary legislation. And so the concept of devolution does, of course, raise a very interesting challenge to the idea of parliamentary sovereignty. And the question really is, well, if Parliament is indeed sovereign, like you say, then why is it the case that these devolved institutions have the power to legislate without the consent of Parliament? Well, the answer to that question is they do not legislate without the consent of Parliament. The reason why devolution exists in the first place is because of parliamentary legislation. Specifically, the Scotland Act, the Government of Wales Act, the Northern Ireland Act, the Good Friday Agreement specifically, all establish devolved administrations and their powers. And so it does raise some theoretical questions. Because despite devolution, we would suggest that even though we have devolution, the United Kingdom remains a unitary state, meaning that Parliament retains the authority to legislate on all matters. And while this is technically true, it is still nevertheless the case that legislation is being passed in Scotland, and legislation is being passed in Wales and Northern Ireland that is regulating different areas of the law. And so it does beg the question of whether or not the United Kingdom is a unitary state or whether or not it's a federal state. Now, some political scientists and constitutional scholars have opted to suggest that it's a sort of quasi-federal state, in the sense that it shares some of the qualities of federalism, in the sense that there are different institutions that are regional within the United Kingdom that do have certain legislative powers, but ultimately, if we scratch at the surface and think about the actual legal implications, Parliament retains its full sovereignty to legislate in a unitary manner against all other institutions. So that concludes this lesson looking at the structure of the UK government. We've examined the principle of the separation of powers within constitutional theory. We've looked at how this principle applies to the United Kingdom with the relative fusion of powers between the executive and the legislative branches. We then looked specifically at Parliament, the House of Commons, the House of Lords, and the doctrine of parliamentary sovereignty, before looking at the role of the Crown, the executive branch, and then finishing by examining the concept of devolution.